in the region in order to ensure that Bosco Ntaganda is arrested and surrendered to the ICC. We are having a third case also within the context of our investigations, and this is going to focus in the Kivus, where we have already had numerous reports of crimes committed by a multiplicity of perpetrators and groups, including numerous reports of sexual crimes. This is the DRC-3 case, and we are aiming for this case at a coordinated approach whereby the national judiciaries of that country and in that region and beyond will take over the cases in order to ensure that all the perpetrators are prosecuted. But the possibility for us to transfer information collected in the course of this investigation will depend on the development locally of protection for witnesses, but also for judges. Let me turn to Uganda, northern Uganda. President Museveni referred the case to us 5 years ago as well. We have done our job, we have investigated, and arrest warrants have been issued for Joseph Kony and 7 leaders of the Lord's Resistance Army, also for crimes against humanity and war crimes happening as early as 2005. But the arrest warrants that have been issued, have not been prioritized by the international community. Negotiations have been allowed, and the Lord's Resistance Army have been able to rebuild and to rearm. Despite the drawn-out peace process, I'm sure you have been hearing about it, and some of you maybe took part, the Lord's Resistance Army have refused to release the children and the sexual slaves that they hold. The UNICEF has been making calls. The SRSG for Children in Armed Conflicts have been making calls for the release of these children, but this is not happening. Joseph Kony has in fact used the Juba talks, the peace talks, to gain time and to gain support, and to rearm and re-attack. The crimes against the civilians that Joseph Kony and the Lord's Resistance Army have been committing have resumed with the same cruelty and across a growing area in northern DRC, in southern Sudan, and close to the Central African Republic. The joint operation by regional states that we have witnessed recently is recognition for the need for action. The fact that the governments of the region acted together with the objective of executing the warrant is an encouraging signal. The capture of the high-level commanders and information gathered on supply networks should help and continue to help in getting the work done against the Lord's Resistance Army. The outstanding warrants of the ICC have to be executed. Let me turn to the Central African Republic. This situation was also referred to the International Criminal Court by President Bozizé. On the 24th of May of 2008, last year, Mr. Jean-Pierre Bemba, a former senator and vice president of the Democratic Republic of Congo, was arrested in the suburbs of Brussels. Mr. Bemba was charged by the ICC for crimes against humanity and war crimes committed in the Central African Republic. His armed militia, the MLC, pursued a plan of terrorizing and brutalizing innocent civilians, in particular during a campaign of massive rapes and looting. Mr. Bemba had already used the same tactics in the past in the Central African Republic as well as in the Democratic Republic of Congo, always leaving behind him a trail of death and destruction. We have presented the documents containing the charges in the case of Jean-Pierre Bemba on the 1st of October, and the confirmation of charges hearing just took place from the 12th to the 15th of January. We as a prosecution believe we have a strong case, and this is the first case where the number of rapes and sexual violence exceed the number of killings. The pretrial chamber has requested us since March to reconsider submitting an amended document containing the charges addressing Article 28 of the statute, that is command or superior responsibility. We have done that, but we have instead decided to charge in the alternative because we believe that the criminal responsibility of Jean-Pierre Bemba covers both Article 28 as well as Article 25(3). In the meantime, the investigations into that case is going on, and we have performed forensic examinations in Bangui, exhumation of grave sites as well as autopsy, and we are very grateful in this regard to the Central African Republic for the cooperation that they have afforded to us. Let me turn to the situation in Darfur, the Sudan. The court issued in April of 2007 2 arrest warrants against Mr. Ahmed Haroun, Minister for Humanitarian Affairs for the Sudan, and Mr. Ali Khousheb, a militia Janjaweed leader. The government of the Sudan continues to refuse to cooperate with the court and to comply with United Nations Security Council Resolution 1593 of 2005, referring the situation in Darfur to the prosecutor of the International Criminal Court. The Office of the Prosecutor has presented a 3rd case in November, just last November, regarding the alleged responsibility of 3 rebel commanders for crimes committed against peacekeepers in Haskanita on the 29th of September 2007. We are hoping to have a decision from the judges this month, and different rebel groups publicly have committed to ensure the appearance of potential suspects in the court. Should the judges rule in favor of our request, our application, judicial proceedings will start very soon. About a month ago, the ICC judges decided that Omar Hassan al-Bashir shall be arrested to stand trial for crimes of rape, extermination, and killings committed against the people of Darfur. The Sudan is obliged under international law to execute the warrant on its territory. If it does not enforce the warrant, the United Nations Security Council, which referred the case to the ICC, will need to ensure compliance. In order to prevent future crimes in Darfur, to avoid thousands of deaths next month, tomorrow, we must act now. After the court's decisions, Omar al-Bashir expelled humanitarian organizations. This is not just an aggravation of the humanitarian crisis. The expulsion of the aid workers is another step in the commission of the crime of extermination. In accordance with the Rome Statute, states parties have to guarantee lasting respect for and enforcement of international justice. States should implement a consistent and a diplomatic campaign to support the court's decision and to deny Omar al-Bashir any form of support. Non-essential contacts with him should be severed. When contacts are necessary, attempts should be made to interact with non-indicted individuals. There are at this time only 3 persons sought by the court: Ali Khousheb, Ahmed Haroun, and Omar al-Bashir. In bilateral and multilateral meetings, state parties should proactively express their support to the enforcement of the court's decision, request cooperation with the court in accordance to Security Council Resolution 1593, and demand that attacks against the displaced, including expelling humanitarian, should cease and should cease immediately. There can be no business as usual attitude regarding the warrant. Strong leadership is required, the kind of leadership we have found in the Great Lakes region. There, African states, African heads of state, have chosen the path of justice and called upon the ICC to help them. National leaders, as well as regional and international organizations, are working together, integrating the tracks of justice, humanitarian assistance, peace, and security. There is still a very long way to go, but they have said no to massive crimes. This is the way forward, and this is not happening for Darfur. Why? There is a need to better integrate the judicial, the humanitarian, and the political efforts. For almost 1 year, the first arrest warrant issued against Ahmed Haroun was ignored by the mediators and the political leaders in their discussions on Darfur. They ignored the court's decisions and they ignored the facts. They ignored Haroun's role in the hack. The main obstacle to humanitarian assistance, they ignored Haroun's membership of the UNAMID Oversight Committee, affecting the deployment of the peacekeepers. In August of 2007, Haroun was appointed head of a committee to investigate human rights abuses, thus providing certainty to other government members that crimes are condoned. A new comprehensive strategy is needed to factor in the information contained in our application and the fact of the arrest warrants. Arrest warrants have to be executed. They not only serve the interest of justice, they can also help to alleviate the humanitarian situation, to facilitate the deployment of operation of peacekeepers, and reach lasting political agreements. It is justice and it is about realpolitik. Massive crimes are not just a moral problem. Massive crimes cross borders, they destabilize entire regions, and they affect the world security. Let me just briefly tell you about the other situations that we are also handling. These are situations in the 5 continents, in 5 countries in 4 continents that are under analysis: Colombia, Georgia, Kenya, Cote d'Ivoire, and Afghanistan. On the 30th of March, upon the invitation of the former Secretary General Kofi Annan, the Office of the Prosecutor participated in the Geneva Conference on Kenya with government representatives as well as members of the civil society. We know the leadership of Kofi Annan there is essential, and we fully support these efforts to encourage local accountability mechanisms. We stand ready to assist Kenya. Also, on the 22nd of January of this year, the Palestinian National Authority lodged a declaration accepting the jurisdiction of the court in accordance with Article 12.3. We have received so far about 326 communications related to the situation of Israel and the Palestinian territory. The office will examine all these issues. In fact, we are examining all these issues related to jurisdiction, related to the, whether the declaration by the Palestinian Authority accepting the jurisdiction of the ICC meets the statutory requirements, and we are also analyzing and examining whether crimes within the ICC jurisdiction have been committed and whether there are national proceedings in relation to these alleged crimes. The court, the ICC, is a 21st century institution, an answer to a 21st century challenges like impunity. Global challenges and international community will be involved because those crimes cross borders. The court's efficiency, its only hope of succeeding, is if this new tool, this new court, can work without having to mimic political institution by adjusting. The court will not adjust to political consideration. Others will have to adjust to the law. And by using this new tool, this law, to manage violence and to put an end to impunity, the international community has taken huge steps to draw clear lines, clear-cut lines when it comes to massive crimes. For example, the Geneva Conventions, the Genocide Conventions, and the creation of the tribunals, culminating in the adoption of the Rome Statute. The court sets limits, red lines, but for us to be efficient, we need the whole of the international community to respect and to uphold these red lines. You should not keep changing lines on a tennis court. Neither do you do so in a football field. Do not do it for more serious issues. Why do we do it for justice? We must give certainty to the criminals, but also the negotiators have to respect the limits. We have all agreed to draw these lines, and as I mentioned before, African countries were essential actors in Rome negotiations. We have taken steps based on the failure of past models, such as amnesties and immunities, on the shared recognitions that never again. This was repeated time and time again. Let me be clear. These lines will only be successful, we will only be successful if all actors abide by them. The court's independence and legitimacy will ensure, but we will only succeed if all actors adjust. These lines, these limits, as well as the court's independence and impartiality will engender and facilitate the collective action of states when it comes to dealing with these massive crimes and putting an end to impunity. Thank you very much for your support. Thank you very much for your patience in listening to me, and thank you for having me in Bemeknaس, Morocco.
Nous remercions Madame Fatou Bensouda pour son analyse très détaillée, relative d'abord aux procédures qui sont en cours, également aux difficultés qui existent, et vous aurez noté que la Cour pénale internationale ou le bureau du procureur ne disposent pas de leur propre police. Il doit donc exister une interaction entre la Cour pénale internationale et les gouvernements nationaux. Analyse difficile selon que la réflexion se concentre sur une approche judiciaire, politique ou humanitaire. Et les conclusions ne sont pas nécessairement les mêmes selon l'aspect que l'on choisit. Ce sera certainement l'occasion de questions et de débats tout à l'heure. We have now the pleasure to welcome Mr. Siva Sivananthan. Mon confrère Siva Sivananthan est un avocat criminaliste de toute première qualité en Malaisie. Il est là en Asie un des confrères les plus réputés, et vous devez savoir qu'il est inscrit sur la liste des avocats qui peuvent intervenir devant la Cour pénale internationale. Il est membre du barreau pénal international et il est également membre du conseil du barreau pénal international. Nous allons maintenant profiter de son expérience et de ses connaissances, et je le remercie de bien vouloir prendre la parole.
Thank you, Pascal. I've actually got the paper that I intend to present today typed up to be distributed. Unfortunately, it's only in English. Perhaps somewhere down the road, some form of translation can be done. So if you can get a copy of the English version, it's there. Now, essentially, the angle that I'm talking about today is whether international criminal tribunals are in fact, do they give you justice, or is it essentially a propaganda exercise. Okay, so it's a critical analysis of international criminal tribunals. And I think this question has become more pertinent now with the Palestine-Israeli conflict, the situation in Sri Lanka, situations in which action cannot be taken because the countries are not signatories to the Rome Statute. There is also the issue of the superpowers not being signatories to the Rome Statute, the more notable ones being the United States of America, China, Russia, and a lot of Southeast Asian countries. So when we talk about international criminal justice, there may be an argument for saying that there is justice if the country concerned is a signatory to the Rome Statute. But if they are not a signatory, then where is the justice? So this is the starting point. We are looking at the concept of justice for the whole of humanity, but yet we have these political issues which prevent justice being given to everyone. An example of which, as you know, and as I read the paper, I will let you know, most situations in countries that have signed the Rome Statute is straightforward. But yet, in certain situations, the United Nations can refer a situation to the ICC. However, before they can refer it, very often, or more often than not, members who sit in the Security Council exercise their veto, depending on which situation is being referred. So, if you look at it from that aspect, it appears that if you are a superpower, you may be in a position to protect people you are interested in from being referred to the ICC. So that is in that context that I'm presenting this paper. Now, just a little bit of background. I'm just going to read excerpts from my paper because I don't want to just read everything. First of all, it'll take too long, and secondly, the paper is actually prepared. Now, for those of you who are not aware, the establishment of special international criminal tribunals and special courts by the United Nations is in fact greatly influenced by two ad hoc international military tribunals, namely the International Military Tribunal for Nuremberg and the International Military Tribunal for the Far East. These two ad hoc IMTs, in short, are known as the Nuremberg trials and the Tokyo trials respectively. So this is where we start off the journey that has led to the formation of the International Criminal Court. These two ad hoc tribunals were established as a result of the Second World War to try individuals who committed war crimes, crimes against peace, and crimes against humanity. Now, shortly after the UN was founded, the International Law Commission of the UN received the mandate to codify the legal principles that emerged during both the Nuremberg and Tokyo trials. Subsequently, the UN established special international criminal tribunals in Rwanda, Yugoslavia, and Cambodia, and also developed special courts in Sierra Leone and Lebanon to prosecute those responsible for atrocities during times of war and genocide. Successful convictions of these political and military leaders are meant to bring justice to victims and to deter others from committing such crimes in the future. These special tribunals and courts gave impetus to the formation of the ICC, which was finally established in 2003. However, these special tribunals and courts have limited jurisdictions and do not threaten the possible prosecution of leaders of nationals of powerful countries like the USA, Russia, and China. Now, this issue, again, just to digress, as you know, during the Clinton administration, I believe President Clinton had actually signed the treaty, but it was not ratified. And subsequently, of course, laws were passed to say that if there was any U.S. national who was subject to any foreign jurisdiction, that would be illegal. And during the Bush administration, of course, because of the Iraqi conflict, that became a non-issue, so to speak, because of the concern that American soldiers in Iraq may be liable to prosecution. And now, of course, we have President Obama, and we really don't know what the situation is going to be. Now, on a personal level, I think when you have a country like the United States, or Russia, or China, who are not members of the ICC, it's a huge void in the effectiveness of the ICC. And to a large extent, these countries become examples for smaller countries, especially in the ASEAN region, who are pretty much tied up to the economies of the US and China, to also follow suit. So they are reluctant to also sign on the basis that why should we sign if these superpowers haven't signed it. It's left to be seen what happens. What I'm trying to say is that when we talk about international criminal justice, this is where the issue of whether it's justice comes about, and it's with great interest that we see the developments. Palestine has agreed to subject itself to the ICC, but whether this actually translates into any prosecutions, well, is left to be seen. Whether, be it Palestine, people from the Palestine or Israeli, whichever way it is, and I'm not going to take a stand as to who, as you know, the tribunals will prosecute any wrongdoers regardless of ethnicity, race, or nationality. So it's really the wrongdoing that's important. Now, the International Military Tribunal for Nuremberg, as you know, the unconditional surrender of the Axis powers led directly to the formation of this International Military Tribunal. The Soviet Union had wanted the trials to take place in Berlin, but Nuremberg was chosen as a site for the trials for specific reasons. Firstly, the Palace of Justice in Nuremberg was spacious and largely undamaged, and a large prison was also part of the complex. Secondly, Nuremberg was considered the ceremonial birthplace of the Nazi Party and hosted annual propaganda rallies. Thus, it was a fitting place to mark the party's symbolic demise. It was also agreed that France would become the permanent seat of the IMT, and that the first trial, of which several were planned, would take place in Nuremberg. Now, again, the Nuremberg trials are unique in the sense that death sentences were issued. As you know, that all these military tribunals that are created, or special tribunals that are created, do not allow for capital punishment, which is, of course, the situation in Iraq was carried out in the Iraqi courts for that reason. Had it been a UN sanctioned tribunal, then the capital punishment would not have been imposed. Now, the definition of what constitutes a war crime is described by the Nuremberg Principles, a document which was created as a result of the trial. The Nuremberg trials had a great influence on the development of international criminal law. The International Law Commission, acting on the request of the UN General Assembly, produced the report of Principles of International Law recognized in the Charter of the Nuremberg Tribunal and in the judgment of the tribunal in 1950. The influence of the tribunal can also be seen in the proposals for a permanent international criminal court and the drafting of international criminal codes, later prepared by the International Law Commission. Now, many commentators feel that the Nuremberg trials represented a step forward in extending fairness to the vanquished by requiring that actual criminal misdeeds be proved before punishment could ensure, and this included some of the defendants and their legal team. The Nuremberg trial has, to some extent, met all these requirements with consideration and dignity, and in a sense, the general assessment of the Nuremberg trials was that it was guided by the search for truth and justice from the first to the last day of the trial. Now, from there you come to the ICTY, which is the Criminal Tribunal for the former Yugoslavia. This is, of course, still current. Situated in The Hague, the Netherlands, the ICTY has charged over 160 persons. Those indicted by the ICTY include heads of state, prime ministers, army chiefs of staff, interior ministers, many other high and mid-level political, military, and police leaders from various parties to the Yugoslavia conflicts. Its indictment addresses crimes committed from 1991 to 2001 against members of various ethnic groups in Croatia, Bosnia, Herzegovina, Serbia, Kosovo, and the former Yugoslav Republic of Macedonia. Now, more than 60 individuals have been convicted, and currently more than 40 people are in different stages of proceedings before the tribunal. Now, what is quite significant of the cases heard at the ICTY is that they have dealt with alleged crimes committed by Serbs and Bosnian Serbs. The tribunal has investigated and brought charges against persons from every ethnic background. Convictions have been secured against Croats as well as both Bosnian Muslims and Kosovo Albanians for crimes committed against Serbs and others. Now, while its judgment demonstrates that all parties in the conflicts committed crimes, the tribunal regards its fairness and impartiality to be of paramount importance. It takes no side in the conflict and does not attempt to create any artificial balance between different groups. Evidence is the basis upon which the prosecution presents a case. The judges ensure a fair and open trial, assessing the evidence to determine the guilt or innocence of the accused. And I think this is something that's quite important because, in a sense, if you look at the Nuremberg trials, it was a culmination of a general feeling amongst the rest of the world about the Nazi war crimes. That was it. So it was, in a sense, a one-sided look at the conflict. There may have very well been crimes committed by the parties that they were fighting against as well. But in that era, the focus was strictly on getting rid of Nazism. Now, what is important today is that as far as bodies like the ICC are concerned, you may have parties from both sides being charged, depending on whether they committed the offense. So it is not, I'm just giving you an example, like on the Israeli-Palestine conflict, you may be taking the Palestinian side and saying that therefore the only ones to be prosecuted are the Israelis. But it could very well be that there may be evidence to also prosecute some Palestinians. So what I'm saying is the issue is not so much whether one party is right or one party is wrong or whatever, but really who are the individuals who have broken the laws which govern international justice. So I think this is the context in which we must understand how the ICC operates, and perhaps sometimes the criticism against it is based on your own political beliefs, as opposed to looking at the nature of the offense committed, and I think that is the distinction that you need to form. It is really a question of what crime was committed by whom, as opposed to as long as it's been committed by this side, it's wrong, but if it's committed by this side, then it should be ignored. So, this is the current problem that we have. You then have the International Criminal Tribunal for Rwanda. I'm not going to go through too much of that. It's in my paper, but I want to go to the International Criminal Tribunal for Cambodia. Now, this is we sorted out the Nazism problem, now it's the killing fields. So everyone has probably seen the movie. We all have this image in our heads of Pol Pot and the terrible things that he did, and the Khmer Rouge, and something needs to be done. But the reality of the Cambodian tribunal is that, first of all, it's taken a tremendously long time to start. Pol Pot himself died, so he's not going to trial. The defendants on trial at the moment are all extremely old, sick, and there is a firm belief or strong belief that many may not even last the trial. And when the tribunal was formed, the Cambodian government, which is led by Prime Minister Hun Sen, who in fact was also an officer in the Khmer Rouge, although the the belief is that he was not involved in any atrocities. He was an officer in the Khmer Rouge himself. Now, one of the conditions of having this tribunal, which everyone wants to have, the UN wants to have it, and most of the world wants to have it because something should be done to the Khmer Rouge, is that if any evidence comes out during the trial which implicates any other officer, those officers cannot be charged. So you have a limited number of accused, that's it. So even if you find any other evidence, one of the conditions of setting up this trial is that you can't charge anyone else. So in a sense, the Cambodian tribunal, if you ask me, again on a personal level, is merely a publicity exercise. You're trying to convict people who